Before you open your safe tonight, before you pick up your rifle for a range session this weekend, before you order that pistol you have been considering, stop and watch this video because of what the Supreme Court just allowed 19 states to do and what they did it to. June 12, 2026. The Supreme Court issued a 5-4 decision in Castillo versus California that has now triggered bans in 19 states on 8 specific firearm configurations that tens of millions of Americans currently own. If you own any of them in one of those 19 states, the effective dates are immediate or imminent, the penalties are felony level, and the compliance window has already been measured and determined. California, New York, Illinois, Massachusetts, New Jersey, Hawaii, Maryland, Connecticut, Delaware, Rhode Island, Vermont, Oregon, Washington, Minnesota, Colorado, New Mexico, Michigan, Nevada, and Virginia. 19 states, 8 specific firearm configurations. One decision that split the court 5-4, and that the Morrison unanimous framework, issued just 5 days earlier, was not powerful enough to stop. Subscribe right now and do not stop this video because what happened in Castillo is the most precise and targeted state firearms restriction in American legal history. Not a broad assault weapons ban that catches everything with a pistol grip. Not a magazine capacity restriction applied across the board. A surgically crafted regulatory approach that identifies 8 specific configurations and gives 19 states the constitutional authority to ban them. Some of these 8 configurations will surprise you. Some will shock you. And at least one is in the safe of a gun owner watching this who does not know it is about to be illegal in their state. Here is the Castillo framework before we get to the 8 firearms. The Morrison decision from June 5, 2026 established that feature-based definitions cannot remove firearms from Second Amendment protection when the underlying platform is in common use. Morrison seemed to end the assault weapons ban era. 5 days later, Castillo issued, and the 5-justice majority, Roberts, Sotomayor, Kagan, Jackson, and Kavanaugh, found a narrow pathway that Morrison's framework itself created. Morrison said the underlying platform must be in common use. Castillo asked, what about specific configurations of that platform that are not themselves in common use for lawful defensive purposes, even if the base platform is? A pistol configuration AR with a 6-inch barrel and no stabilizing brace, is that specific configuration in common use? A rifle with a binary trigger factory installed, is that the platform in common use or a distinct modified configuration? The Castillo majority held that while the underlying semi-automatic platform in standard configuration is protected by Morrison's common use analysis, specific configurations can be identified and regulated separately if the state demonstrates that the specific configuration has no significant defensive use case, has design characteristics approximating automatic weapons function, and is not itself in common use for lawful civilian purposes in the specific configuration banned. The 4 conservative justices, Thomas, Alito, Gorsuch, Barrett, dissented sharply, arguing Castillo eviscerates Morrison by allowing states to target any configuration with specificity sufficient to distinguish it from the protected base platform, a workaround that makes Morrison's protection meaningless. Number 1. The first 4 banned configurations. Configuration 1. AR platform pistols with barrels under 8 inches and no stabilizing brace. An AR-15 in standard rifle configuration is fully protected by Morrison. An AR pistol with a stabilizing brace is protected as a pistol configuration. What Castillo reaches is the AR platform pistol with a barrel under 8 inches and no stabilizing brace, sometimes called a bear pistol, a configuration that became common after owners removed braces following the ATF's regulatory changes. The Castillo majority held this specific configuration has no significant defensive use case, too small for rifle effectiveness, too large for pocket carry, no stabilization mechanism, approximates the function of an unregistered short-barreled rifle, and is not itself in common use as a specifically identified configuration. If you own an AR platform pistol with a barrel under 8 inches without a brace in one of the 19 banned states, this applies to you. Configuration 2. Binary trigger-equipped rifles that are factory configured. The ATF's deregulation package removed regulatory threats to binary triggers, and Morrison protects semi-automatic rifles generally. But Castillo reaches a specific subset, rifles manufactured and sold from the factory with binary triggers pre-installed as the standard trigger mechanism, rather than having binary triggers added aftermarket. The majority's reasoning is that a factory binary trigger rifle is itself a distinct configuration. not in common use as a specifically identified product category, and approximates automatic fire capability more closely than a standard semi-automatic rifle with an aftermarket modification. A rifle you buy and then install a binary trigger in is protected. A rifle sold from the factory with a binary trigger as its standard mechanism is banned in 19 states. This distinction will generate substantial litigation about what factory configured means and how it differs from dealer installation. Configuration 3. Rifle caliber pistols with magazines exceeding 30 rounds and barrels under 10 inches. This configuration targets a specific combination: rifle caliber 5.56, 7.62, .300 blackout, pistol length barrel under 10 inches, and a magazine capacity exceeding 30 rounds. Any single characteristic alone does not trigger the ban. A rifle caliber pistol with a standard 30-round magazine is not reached. What Castillo reaches is the specific combination: short barrel rifle caliber platform with extended magazine capacity, which the majority characterized as having no established defensive use and design characteristics suggesting primary utility in high-volume fire applications inconsistent with traditional civilian firearm uses. Most commonly owned rifle caliber pistols will not meet all three criteria simultaneously. But if you own a 5.56 pistol with a 6-inch barrel and a 50-round drum, Castillo reaches that specific combination. Configuration 4. .5 OB-MG semi-automatic rifles with detachable magazines, Barrett M82. Semi-automatic rifles chambered in .5 OB-MG with detachable box magazines. California has banned .5 OB-MG rifles since 2004. What Castillo does is provide the first Supreme Court constitutional validation for .5 OB-MG semi-automatic bans in states that have them, and the first affirmative authorization for states that do not yet have them to implement them. The majority held that the specific combination of .5 OB-MG bore diameter, bullet energy, and semi-automatic rate of fire with detachable magazine creates a configuration primarily suited to anti-materiel and crew-served applications. The four dissenters argued that .5 OB-MG rifles are in common use for long-range shooting competitions, and that restricting a caliber based on military origin is exactly the dangerous and unusual analysis Morrison rejected. Number 2. The final four banned configurations. Configuration 5. Bullpup rifles with barrels under 14 inches and overall length under 24 inches. Castillo reaches not bullpup rifles generally, but a specific subset: bullpup configurations with barrels under 14 inches and overall length under 24 inches. This combination, shorter than a standard rifle in both barrel length and overall dimensions, is characterized as a configuration that achieves the functional advantage of a short-barreled rifle while occupying the classification of a long arm, creating an NFA circumventing design the state can specifically target. IWI TAVR SAR in certain configurations and similar firearms in this specific size range are affected in 19 states. Configuration 6. Semi-automatic shotguns with box magazines exceeding 5 rounds and barrels under 14 inches. Saiga 12 and Viper 12, patterned semi-automatic shotguns in specific configurations. Castillo reaches shotguns that are both magazine-fed with capacity exceeding 5 rounds and configured with barrels under 14 inches. A standard semi-automatic shotgun with a fixed tube magazine is not reached. A box magazine semi-automatic shotgun with a longer barrel is not reached. The specific combination of extended box magazine capacity and shortened barrel length, creating what the majority characterizes as a high-volume fire close-quarters configuration, is what Castillo addresses. Configuration 7. Pistols with fully enclosed barrel shrouds and standard magazine capacity over 20 rounds. This is the most unusual of the 8 configurations and the one that will generate the most litigation about scope. Certain pistol configurations include barrel shrouds, enclosed tubes surrounding the barrel, that the Castillo majority characterized as design features associated primarily with military submachine gun aesthetics and function. Combined with magazine capacity over 20 rounds, this specific combination is targeted. Some PDW-style pistol configurations and similar firearms with specific barrel shroud features and high-capacity magazines are affected in 19 states. The precise definition of fully enclosed shroud is highly contested, and multiple preliminary injunction motions specifically challenge this definition. Configuration 8. Pistols converted to fire rifle cartridges through conversion kits. This configuration reaches a specific practice. commercially available conversion kits that adapt pistol platforms to fire rifle cartridges. Glock to 5.56 conversions. Pistol to rifle cartridge adapters. A pistol in standard configuration firing pistol caliber ammunition is fully protected. A rifle firing rifle ammunition is fully protected. The specific combination of a pistol platform with an installed conversion kit enabling rifle cartridge fire is what Castillo reaches, characterizing it as a distinct, newly created configuration that has not established itself in common use and has no significant established defensive use history. Number 3. The 19 states and their specific implementation. Immediate effective dates: June 12th to 20th, 2026. California, New York, and Illinois implemented emergency administrative action within 24 hours of Castillo, using existing assault weapon frameworks that pre-positioned them for rapid implementation. If you are in these 3 states, the bans are already in effect. Short-term effective dates: June 20th to July 15th, 2026. New Jersey, Hawaii, Maryland, Massachusetts, Connecticut, Delaware, and Rhode Island activated pre-drafted legislation. Attorney General opinions clarifying coverage were issued with effective dates between June 20th and July 15th. Legislative action states: July 15th to September 1st, 2026. Oregon, Washington, Vermont, Minnesota, Colorado, New Mexico, Michigan, Nevada, and Virginia, implementing through emergency legislative sessions or fast-track enactments. Effective dates range July 15th through September 1st. Virginia's implementation creates particularly complex compliance obligations operating simultaneously with HB 217/SB 749. Compliance windows across all 19 states. California, 30 days, June 12th to July 12th. New York, 45 days through August 1st. Illinois, 60 days through August 12th. Legislative action states: 30 to 60 days from each state's effective date. All 19 states provide zero compensation for surrendered firearms. Number 4. The penalties you face and your compliance options. Criminal penalties. Existing assault weapon penalty states: California, New York, New Jersey, Illinois, Massachusetts, Maryland, Connecticut, Hawaii, Delaware, Rhode Island, apply existing felony schemes. Class C or D felonies, 3 to 7 years prison, permanent loss of firearms rights. Legislative action states enacting new penalties. Class B misdemeanor for first-time possession in some states. Class C felony in others for possession with prior violations. All 19 states. Conviction means permanent prohibition from future firearm ownership. Your 5 compliance options. Option 1. Surrender to law enforcement during compliance window. No criminal penalty. No compensation. Firearm destroyed. Get a receipt documenting what you surrendered and when. Option 2. Transfer to out-of-state buyer in a non-banned state. Must use a licensed FFL. Transfer must complete before your state's effective date. Out-of-state buyer must be legally entitled to receive the firearm. You receive fair market value. Act now. Demand in non-banned states is high and compliance windows are closing. Option 3. Reconfigure the firearm to remove the characteristics triggering the Castillo ban. An AR platform pistol with a sub-8-inch barrel can have a stabilizing brace added. A bullpup in a banned size range can potentially have its barrel lengthened. Whether reconfiguration is legally viable depends entirely on your state's specific implementing language. Consult a firearms attorney before relying on this option. Option 4. Relocate to a non-banned state. If you are near a state line or already planning a move, completing relocation before your state's effective date and establishing non-banned state residency preserves your ability to keep covered configurations legally. Option 5. Out-of-state storage. Storing a covered configuration at a facility in a non-banned state before your state's effective date may avoid the possession within the state prohibition. This is highly fact-specific and requires attorney guidance specific to your state's implementation language. Number 5. What non-banned state residents must know. Your configurations remain fully legal. All 31 states not implementing Castillo bans have no obligation to do so. Castillo authorizes configuration-specific bans. It does not require any state to implement them. Texas, Florida, Georgia, Arizona, Tennessee, Ohio, Indiana, Missouri, Oklahoma, Kansas, and 20 other states are completely unaffected. Interstate travel risk. Castillo bans apply to possession within the 19 banned states. Travel through a banned state with a covered configuration in your vehicle raises legal uncertainty. Morrison's interstate carry floor protects carry of protected firearms, but Castillo creates a category of configurations that fall outside Morrison's common use protection, creating ambiguity about whether Morrison's interstate protection extends to Castillo-banned configurations. Until courts resolve this question, the safest approach when transiting a banned state with a covered configuration is to treat the firearm as in transit under FOPA's safe harbor: locked container, unloaded, inaccessible. Dealer and manufacturer considerations. If you operate a dealership or manufacture covered configurations in a non-banned state, sales to banned state residents and FFLs raise facilitation concerns. Most responsible dealers are declining to complete such sales until legal guidance is published. The National Shooting Sports Foundation is providing updated guidance to member manufacturers and dealers. Number 6. The legal landscape. Why preliminary injunctions may help but cannot be relied upon. The preliminary injunction standard. Gun rights organizations are seeking preliminary injunctions in California, New York, Illinois, New Jersey, and other states. The preliminary injunction standard requires likelihood of success on the merits, irreparable harm, favorable balance of equities, and public interest. Directly challenging Castillo's constitutional holding is difficult given the 5-justice majority, but challenging specific states' implementations of Castillo, where states have drafted configuration bans more broadly than Castillo authorizes, has better prospects. Why you cannot rely on a pending injunction. Injunctions can be denied. Injunctions can be stayed pending appeal. Injunctions can be reversed. If your compliance window closes while an injunction is pending and the injunction is then denied or reversed, you could be found in violation from the moment your window closed. Take compliance steps within your window and treat any injunction as a bonus, not a backup plan. What a successful challenge looks like. The most viable path for successful legal challenges is not arguing that Castillo was wrongly decided, but rather arguing that specific state implementations exceed what Castillo actually authorized. Castillo permits configuration-specific bans when the specific configuration is not in common use, has no significant defensive use, and approximates regulated weapon function. States that have drafted their implementation language to capture configurations that do have common use, significant defensive use, or no close approximation to regulated weapons can be challenged on the grounds that they exceed the Castillo authorization, even taking Castillo itself as settled law. The Thomas dissent's prediction and its importance. Justice Thomas predicted in his Castillo dissent that the combination of Morrison and Castillo creates an unstable constitutional environment in which firearms owners can never be certain which configurations are fully protected and which are configurations specifically targetable. If Thomas is right, and the breadth of state implementation in the 48 hours following Castillo suggests he may be, the post-Morrison landscape requires constant legal vigilance rather than the stable platform of expanded rights that Morrison's unanimity seemed to promise. Number 7. Your complete action plan starting today. Step 1. Identify what you own against the 8 configurations. A R platform pistol with barrel under 8 inches and no stabilizing brace, factory binary trigger rifle, rifle caliber pistol with over 30 round magazine and barrel under 10 inches, .50 BMG semi-automatic with detachable magazine, undersized bullpup, box magazine semi-auto shotgun with short barrel, pistol with barrel shroud over 20 rounds, pistol with rifle cartridge conversion kit installed. Go through your safe now. Step 2. Know your state's effective date and compliance window. California, July 12th. New York, August 1st. Illinois, August 12th. Legislative action states, July 15th through September 1st. Know your deadline precisely. Do not guess. Step 3. Consult a firearms attorney before doing anything. The configuration bans are legally complex. The line between covered and exempt is not always clear. Reconfiguration options have legal uncertainty. Transfer procedures have compliance requirements. Before you surrender, transfer, reconfigure, or take any other action with a potentially covered firearm, spend 1 to 2 hours with a firearms law attorney in your state who has reviewed your state's specific Castillo implementation. That investment could prevent a felony charge. Step 4. If transferring to an out-of-state buyer, act immediately. FFLs handling Castillo-related transfers are reporting increased volume. Out-of-state demand for covered configurations is high, and prices are at a premium in non-ban markets. Completing your transfer now rather than in the final days before your compliance window closes ensures availability and value. Step 5. Document all compliance actions thoroughly. Surrender receipt from law enforcement. FFL transfer records and sale documentation. Photographs and part records if reconfiguring. Storage agreement and transfer documentation if moving to out-of-state storage. Documentation of compliance may be critical if your compliance is ever questioned. Step 6. Monitor preliminary injunction developments daily. The FPC, SAF, and GOA are filing preliminary injunction motions in multiple districts. Court decisions will come quickly given the compressed effective date timelines. Follow these organizations for real-time updates. But remember, monitor as informational, not as a substitute for compliance. Step 7. Join and fund the organizations fighting Castillo. The legal challenges to Castillo and its implementations will be expensive, multi-year, and critically important to the future of the Morrison Framework's protection. The Firearms Policy Coalition, Second Amendment Foundation, Gun Owners of America, and National Shooting Sports Foundation need your membership, donations, and activist support. This legal fight determines whether Castillo's configuration-specific exception swallows Morrison's protection, or is constrained to the narrow pathway the 5-justice majority claim to be creating. Bottom line. Castillo versus California, June 12, 2026. 5-4. A narrow Supreme Court majority found a configuration-specific exception to Morrison's common use protection. 8 banned configurations. AR platform pistols under 8 inches without brace. Factory binary trigger rifles. Rifle caliber pistols over 30 rounds under 10-inch barrel. .5 OBMG semi-autos with detachable magazines. Undersized bullpups under specific dimensions. Box magazine shotguns under 14-inch barrels over 5-round capacity. Pistols with barrel shrouds and over 20-round magazines. Pistols with rifle cartridge conversion kits installed. 19 banned states: California, immediate; New York, August 1st; Illinois, August 12th; New Jersey, Hawaii, Maryland, Massachusetts, Connecticut, Delaware, Rhode Island, Vermont, Oregon, Washington, Minnesota, Colorado, New Mexico, Michigan, Nevada, Virginia. Effective dates range from immediate to September 1st. Zero compensation for surrendered firearms. Compliance options: surrender to law enforcement, transfer to out-of-state buyers through FFL, reconfigure to remove banned characteristics, relocate to non-banned state, out-of-state storage. All require attorney consultation to implement correctly. Non-banned states. 31 states have no obligation to implement. Interstate travel through banned states with covered configurations is legally uncertain. Use FOPA safe harbor provisions when transiting. Action plan. Identify what you own against the 8 configurations now. Know your compliance deadline. Consult attorney. Transfer now if that's your path. Document everything. Monitor injunction litigation. Support FPC, SAF, GOA. Subscribe because Castillo's implementation and challenge litigation is moving in federal courts across 19 states simultaneously, and every development in that litigation directly affects whether these bans stand or are constrained to what the 5-justice majority actually authorized. 8 guns, 19 states, one decision that used Morrison's own framework against itself.